Hello. Welcome to our YouTube channel. If you are new here, please subscribe. This is another case where the Supreme Court applied the Doctrine of Apparent Authority. This is the case of Advanced Paper Corporation versus Arma Traders Corporation, penned by Justice Breon. Petitioner Advanced Paper is a domestic corporation engaged in the business of producing, printing, manufacturing, distributing and selling of various paper products. Respondent Arma Traders is also a domestic corporation engaged in the wholesale and distribution of school and office supplies and novelty products. Respondent Tan and U were formerly the president and treasurer of the Respondent Corporation. They represented Arma Traders when dealing with its supplier, Advanced Paper, for about 14 years. On various dates from September to December 1994, Arma Traders purchased on credit notebooks and other paper products from Advanced Paper. Upon the representation of Tan and U, Arma Traders also obtained 3 loans from Advanced Paper in November 1994 totaling more than 7 million pesos. As payment for the purchases on credit and the loan transactions, Arma Traders issued 82 post-dated checks payable to cash or to Advanced Paper. Tan and U were Arma Traders' authorized bank signatories who signed and issued these checks. Advanced Paper presented the checks to the Drui Bank, but these were dishonored either for insufficiency of funds or account closed. Despite repeated demands, however, Arma Traders failed to settle its account with Advanced Paper. Then on December 29, 1994, the petitioners filed a complaint for collection of sum of money with application for preliminary attachment against the respondents. The Respondent Corporation and its current directors argued that the purchases on credit were spurious, simulated and fraudulent since there was no delivery of the 7 million worth of notebooks and other paper products. During the trial, the corporation, through its corporate secretary, testified that Arma Traders did not purchase notebooks and other paper products from September to December 1994. As to the loan transactions, the respondents countered that these were the personal obligations of Tan and U to Advanced Paper. These loans were never intended to benefit the respondents. The respondents also claimed that the loan transactions were ultra vires because the board of directors of Arma Traders did not issue a board resolution authorizing Tan and U to obtain the loans from Advanced Paper. Hence, the petitioner must suffer the loss. The RTC ruled that the purchases on credit and loans were sufficiently proven by the petitioners. The trial court held that the respondents failed to present hard, admissible and credible evidence to prove that the sale invoices were forged or fictitious, and that the loan transactions were personal obligations of Tan and U. The Court of Appeals reversed the trial court. The appellate court ruled that Arma Traders was not liable for the loan in the absence of a board resolution authorizing Tan and U to obtain the loan from Advanced Paper. The issue brought before the Supreme Court is whether Arma Traders is liable to pay the loans applying the Doctrine of Apparent Authority. The Supreme Court granted the petition and held that Arma Traders is liable to pay the loans on the basis of the Doctrine of Apparent Authority. The court held, quote, "The Doctrine of Apparent Authority provides that a corporation will be estopped from denying the agent's authority if it knowingly permits one of its officers or any other agent to act within the scope of an apparent authority, and it holds him out to the public as possessing the power to do those acts. The Doctrine of Apparent Authority does not apply if the principal did not commit any acts or conduct which a third party knew and relied upon in good faith as a result of the exercise of reasonable prudence. Moreover, the agent's acts or conduct must have produced a change of position to the third party's detriment. In the present petition, we do not agree with the CA's findings that Arma Traders is not liable to pay the loans due to the lack of board resolution authorizing Tan and U to obtain the loans. To begin with, Arma Traders' Articles of Incorporation provides that the corporation may borrow or raise money to meet the financial requirements of its business by the issuance of bonds, promissory notes and other evidence of indebtedness. Likewise, it states that Tan and U are not just ordinary corporate officers and authorized bank signatories because they are also Arma traders and corporators. Furthermore, the respondent's corporate secretary testified that the sole management of Arma traders was left to Tan and Yu, and that he and the other officers never dealt with the business and management of Arma traders for 14 years. He also confirmed that since 1984 up to the filing of the complaint against Arma traders, its stockholders and board of directors never had its meeting. Thus, Arma traders bestowed upon Tan and Yu broad powers by allowing them to transact with third persons without the necessary written authority from its non-performing board of directors. End of quote. The lesson therefore in this case is that a corporation's failure to take the necessary precautions to prevent its own corporate officers from abusing their powers, and its own laxity in its business dealings, the corporation will be estopped from denying the authority of its erring officers. This is true even without the required board resolution such as what happened in this case. We hope you learned something useful in this video. Thank you. If you liked this video, please subscribe to our channel and like our Facebook page ECS Notes. You may also comment and share this video to your friends. Have a pleasant day.